Well, good morning, everyone, and welcome to our July Mortgage Quality and Compliance webinar. This is Susan Milazzo with the California MBA. I'm very happy that you could join us today. So before we get into today's presentations, just have a couple of pieces of information to give you. You might have seen our information in social media and on our website, but all of our conferences over the summer and this fall have been turned to virtual events. We are using a very robust virtual conference platform. So I know that if you are planning on attending any of our conferences this summer, you will have a great experience in our virtual world. We have our Mortgage Innovators Conference coming up in August. If you are a lender, you have the ability to participate in that conference free of charge, so check that out. Also, we're running a promotion if you register before the end of July for that conference. You will be entered to win a $500 Amazon gift card. So I know that it's easy to wait till the last minute because it's a virtual conference, you don't have to plan any travel. But if you know that you're going to participate in the Mortgage Innovators Conference, I suggest you do it here in the next week and enter to win that cool prize. We also have our Western Secondary Market Conference coming up in September, and information on registration for both of those events, as well as our Commercial Real Estate Finance Conference, are available on our website, cmba.com. So with that, I will go ahead and get us started with today's presentation. We're going to start off with information on legislation we're following with our lobbyist, Pat Zenzela. Pat, I'll turn it over to you.
Thank you, Susan. First, I'll start with where we're at in the legislative process. The legislature actually has been basically recessed, or they adjourned because of the COVID crisis. They're scheduled to come back next week and do their sprint to the constitutionally declared ending point, which is August 31st. And so basically all of the bills that are still alive have passed out of the first house and they're in the second house. What I'm going to talk about today are three bills that could impact our industry. The first one is AB 828. So the in-print version of this bill would prohibit a residential foreclosures during a state or local government declared state of emergency, and continue that until 15 days after the state of emergency is lifted. It also has, and really the main focus of the bill actually is with respect to protecting tenants in rental units. So it has extensive provisions that deal with unlawful detainer court actions, restricting the ability to evict rental tenants, etc. We have received from the author's office a mock-up with amendments to the bill, so they're not in print yet. Among other things, the amendments would prohibit a foreclosure or filing of foreclosure documents with the county recorders during that, once again, state of emergency declared by either the state or local government, and for 90 days after it ends. So they're extending the time frame. And then they also include new language that says basically you'd have to file with any non-residential foreclosure that is recorded. You'd have to file a new affidavit stating that the property that's being foreclosed on is not a residential property. And if you do that falsely, or if it's not correct, it would invalidate any foreclosure sale in those cases where information was either false or omitted. So anyhow, that bill is very problematic. We have an opposed position on that bill, and it's an urgency bill, so it actually would take effect immediately if it were to pass the legislature, and it would require, the good positive is it would require a 2/3 vote. So hopefully we have an opportunity to stop that bill from moving or to remove the foreclosure provisions. The next bill I want to mention is AB 1436. This is a bill that was amended in the second house. Its main focus is on, once again, rental housing tenant relief in response to the COVID crisis, but they recently included new intent language. So no specific provisions, but intent language regarding providing mortgage forbearance and foreclosure protections on these residential rental properties. They want to provide protections to the owners, the landlords of the property. And the feedback is from the author's office that they want to add some kind of mortgage forbearance relief for these residential landlords, that are experiencing problems as far as getting rent payments, et cetera. So they want to cover both the tenant side and the landlord side. So this is something that we'll be watching very closely to see what amendments go in. So far, we have not received any of the detailed feedback in that regard. And then the final bill I want to mention is AB 1703. This is, once again, a bill that was amended in the second house, and it would require an owner of a residential property that's occupied by a tenant or any multifamily residential property to take various specified actions before they can offer the property for sale. It does specifically exempt a single family property that an owner occupies. So it would, exempt any owner occupied residential property. But obviously, devils in the details as far as how that work and whether you would have that information. It puts all kinds of new requirements on an owner of the property before they can sell it. Won't get into details as far as that's concerned, but specifically with respect to the mortgagee, trustee, beneficiary, or the authorized agent, upon filing a notice of default, so once you begin the foreclosure process, you would have to, the mortgagee or trustee would have to provide a list of qualified organizations, and the bill determines what that is, located within the county, to any of the tenants that live in the residential property that's the subject of the foreclosure. So basically, you'd have to provide these tenants specific, addressees with this information to allow them to be able to utilize the rental protections that are in the bill, and the ability to essentially purchase a house before anybody else buys it. Very problematic because the trustee, the mortgagee, et cetera, wouldn't necessarily have any of the specific details on tenants living in these residents. So we oppose this bill also, and the provisions of the bill would be in effect until January 1st, 2023, if it does pass. So those are the three bills that I want to mention. Once again, we'll be focusing on these in the final few weeks of the legislative session.
Right. Okay. Well, thank you, Pat. I know quite a bit going on in the legislature these days, and it's tough to know kind of what lies in store for us. We've got a few weeks. Session ends at the end of August. We may or may not go into a special session after that, so we'll be watching all that. And Pat, thank you so much for all that you do on behalf of the industry. We really appreciate it.
Thank you, Susan.
So with that, we will turn it over to our General Counsel, Michael Pfeiffer. Michael, I would like to turn it over to you and talk with us about the current update in the world of litigation.
Thank you, Susan. This is one of those days where things just haven't gone right. For some reason, right in the middle of Pat's discussion, my network administrator decided to shut down my computer for some reason. I'm just booting it up right now, but I have my slides in front of me, and so if you can kind of advance them for everybody, then sure. I think we can proceed fine while I'm rebooting here.
Sure. So I'm starting on the first slide. Yeah.
Okay. That's the title slide.
The first slide of your presentation, where it's on the CELA law versus CFPB. Right,
exactly. If you could go to slide 2, which gets into the more of the specifics. I'll catch up to you in a minute, but just going to take a while here. I call this part 3 of CELA Law LLC because I've previously reported on this case, And maybe you're getting tired of me talking about it, and maybe you think everybody thinks they know a lot about this case, and I'm sure some of you do. Some of you, I'm sure, more than I do. But this definitely bears some serious analysis and review. The case is getting an echo. I don't know where that's coming from, but the case is I think will be a landmark. In history, we'll view it as a landmark case. I reported back in September of 19 that it was that a petition for certiorari to the Supreme Court had been submitted from the Ninth Circuit's decision upholding the constitutionality of the CFPB, and then in October the case had been accepted for review, and they discussed some of the potential issues and things associated with that. I outlined some of those issues, and then of course at the end of June, the 29th of June, the Supreme Court actually issued its ruling. And I'm going to explain what that ruling is, but I want to quickly just bring everybody back up to speed. If you go to the next slide, slide 3, Susan, where it says background.
Okay, okay, that's where I'm at.
Got it. This started with a petition to enforce a civil investigative demand. It was issued by the CFPB, and it was resisted by this law firm. The district court in the Central District of California, which is basically the Los Angeles area, granted the petition and ordered the law firm to comply with the CID, and then that started the appeal process. They appealed to the Ninth Circuit, and the Ninth Circuit, the arguments were presented that the structure of the CFPB violated the separation of powers of the U.S. Constitution because it allowed the director to be fired only for cause, which included inefficiency, neglect of duty, or malfeasance in office. And in their decision on May 6, 2019, the Ninth Circuit said, no, sorry, the CFPB is constitutionally permissible. That kind of single director removal only by cause is constitutionally okay, and they upheld the CID. They said it didn't violate certain other exclusions, and so then that set up the appeal to the Supreme Court. As I indicated, they petitioned for cert in June of 2019. October 19, the Supreme Court granted the petition, and then on June 29th, they issued their decision. So what did they say? Let's go to slide 4. They had 4 choices. They could have declared the single debtor structure constitutional. They could have declared it unconstitutional and forced the issue back to Congress to decide what to do about it. They could adopt the position of the then D.C. Circuit Judge Kavanaugh in the PHH case that while the single director structure is unconstitutional, it can be remedied by allowing the president to terminate the director without cause. And then number 4, it could have declared all independent agencies, even ones under the directorship of commissions, to be unconstitutional because they are effectively a 4th branch of government not authorized by the Constitution. Those 4 choices illuminate the issues at play in this decision. So now I'm back up. I can see everybody. I can see the slide. So if you go to the next slide, please. The opinion was written by Justice Roberts, but it's interesting to see the political alliances, I guess. And of course, Justice Roberts says there is no political alliance in the Supreme Court. Technically, that's supposed to be true, but things have a way of reflecting otherwise. The main part of the opinion, which was the part declaring was unconstitutional, Justice Roberts was joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh. Those are the supposedly conservative branches of the court, holding that the structure as a powerful agency headed by a single director, removal only for cause, violates the separation of powers principles embodied in the Constitution, in particular Article 2, that empowers the president to execute the laws of the land. And then the second part, Justice Roberts was joined by Justices Kagan, Ginsburg, Breyer, and Sotomayor, which is considered to be the more liberal side of the court, in holding that the violation is cured by severing the for-cause removal restriction and making the director answerable to the president. It's kind of interesting way that played out. Still ended up being a 5-4 decision, but it was basically 2 parts getting to the 5-4. If you go to the next slide, I've included a quote from the decision, and it's there. I'll go over it quickly. We are now asked to extend the precedence of various they're talking about precedents involving various commissions that had multiple leaders, panels and boards and that sort of thing, and basically saying this is the only time when we have a single individual who cannot be removed by the president unless certain criteria are met. We decline to extend the precedents pertaining to such other agencies with respect to the CFPB. And such an agency lacks foundation in historical practice and clashes with constitutional structure by concentrating power in a unilateral actor insulated from presidential control. They said that it therefore violates the separation of powers, and the agency must continue to operate, but its director must be removable by the president at will. So if you go to the next slide, Susan. This is, to me, this is the core quote, the sort of the money quote from the opinion. The structure contravenes the calibrated system of vesting significant governmental powers in the hands of a single individual accountable to no one. These are the things we've been saying about the CFPB since 2010, when it was put into Dodd-Frank and set up. And the Supreme Court finally acknowledged all of these things and pointed out that the director doesn't even depend upon Congress for annual appropriations and could unilaterally, without meaningful supervision, issue final regulations, oversee adjudications, set enforcement priorities, initiate prosecutions, determine penalties, etc. Investigator, cop, judge, jury, and execution are all wound up into one. This is a monumental statement that reaffirms the whole structure of basically the three branches of government in the United States. And for decades, we've been trending toward a sort of rule by agencies and ruled by bureaucrats. And this decision basically says, no, we're not gonna do that. That's not where we're gonna go with this. Next slide. They emphasize in this part of the opinion that the CFPB is also outside the appropriations process, which and very wealthy because of that. And they basically just drew a line in the sand and said, no, we're not going to go any farther down this road. Next slide. And I'm not going to read through all of these, but this points up a really key thing. Because the director was appointed for a 5-year term, it was very possible and conceivable that a president could be elected that never would have the opportunity to appoint a director and be totally insulated from the public. I think that was what was intended when the CFPB was set up, that the unwashed electorate would get involved in messing up the carefully laid plans of rule by those superior to us. But I think it kind of backfired, because if you go to the next slide, basically what this means is that this decision means is that it's going to be in the hands of the president. A lot of people don't like the president right now. A lot of people didn't like the previous president, but at the end of the day, the president is elected by the people and is accountable to the people, and the people have a vote on it. And I think the Supreme Court said, that's what America is all about. And we're not going to be ruled by technocrats, people who know better than we do or think they know better than we do. In the end of the day, maybe it's a slow process, but at the end of the day, the people get to have something to say about it. Interestingly, and this is sort of the end, the court remanded to the district court the decision as to whether to actually enforce the civil investigative demand, which is what started the whole thing. So this was this whole saga was basically an exercise in watching the principles of America unfold. And I believe that this case will be cited numerous times in the future for a lot of different things, but basically for this standard. Next slide. Things are already happening as a result of this. There was an article on July 19th in the American Banker by Kate Berry talking about the uncertainty about the political process, which is causing banks to be leery of introducing small dollar lending. Things are going to be much more politically oriented, much more attuned to what happens in the country. And although we'd like to decry the politicization of a lot of things, government is a political entity. And so it'll be up to the people, I guess, to see if we're capable of electing presidents who can appoint and retain directors capable of wisely balancing the needs of consumers with what we all know are the complex realities of the financial services industry. That's my presentation, Susan.
Great, thank you, Michael. I appreciate that. You know, that was, I know, a case that lots of eyes were on. So thank you for that that update. I'm going to go ahead and start. Oops, hang on one second. I'm going to go ahead and turn it over to our committee chair, Carol Carson. Carol, I can turn the over to you so you can introduce our speakers today.
Hi, Susan. Thank you so much, and welcome, to everybody for joining today's presentation. Our feature presentation today is offered by, we have two speakers today, both very, very qualified on the subject, and I want to introduce them to you. First, we have Janet Twombly. She is with the Compliance Group. She has over 25 years of experience with extensive background in loan servicing operations, including reverse mortgages, compliance, audit oversight, and risk reporting. She has been successful in identifying and assessing key risk areas and providing meaningful reporting metrics to senior management. She was instrumental in building and managing loan servicing division for several lending institutions. And she is currently, as I said, directing the Compliance Group's loan servicing and compliance divisions. She manages an internal staff to stay abreast of all federal and state regulations with respect to servicing and miscellaneous audits, including MERS annual report reviews. Janet also oversees the California per diem interest and related disclosure and recording fee audits for numerous clients that her company has engaged with. And Janet is an expert with knowledge in conducting comprehensive servicing reviews to determine if the client is adhering to internal policy and procedures along with complying with their appropriate regulators. In addition to Janet, we have my colleague at Plaza Home Mortgage, Greg Watson. Greg is the AVP for the shipping department at Plaza. Greg received his bachelor's degree from the University of Redlands and began his career at an online training company specializing in OSHA compliance. After a few years of doing that, Greg found his permanent home at Plaza, then a company in its infancy. Greg was instrumental in building Plaza's post-closing and shipping departments and has been with the company for 18 years now. Greg has been very involved with MERS and has been a panelist speaker at MERS annual conferences. Welcome to you both, Janet and Greg. We're looking forward to hearing what you have to say. And Greg, I'm going to turn the microphone over to you.
Well, thank you, Carol. And thank you for everyone for joining. I appreciate your time. It's a pleasure to be here and to be a part of this presentation. So before I get started, I'm going to run through a little MERS background so everybody kind of knows what MERS is. MERS Corp Holdings, Inc. is the parent company of Mortgage Electronic Registry Systems, Inc. and owns and operates the MERS system. It's an electronic registry of mortgage loans that tracks transfers of servicing rights and beneficial ownership interests. The company was established in October of 1995 with the first registration of mortgage loans in the MERS system occurring in 1997. Intercontinental Exchange, Inc. completed its acquisition of MERS Corp Holdings, Inc. in October of 2018 after acquiring the majority of the stock in 2016. Per quick MERS facts, MERS has over 5,000 MERS system members. More than 2/3 of all mortgage originations are registered in the MERS system. MERS, as the original mortgagee, eliminates the need to record assignments of mortgages in county land records as servicing rights or beneficial ownership rights transfer. MERS's mortgagee also receives legal notices and serves as a process for mortgage properties and transmits this information to the appropriate MERS system member. Those benefiting from this electronic registry include mortgage lenders, servicers, warehouse lenders, document custodians, title companies, settlement agents, investors, and consumers. Slide. Okay, so we're going into MERS responsibilities, but before I get started on that, I just want to read our disclaimer really quickly. This information is published and provided by Plaza Home Mortgage and intended for mortgage professionals only, as a courtesy to its clients, and is meant for instructional purposes only. It's not intended for public use or distribution. None of the information provided is intended to be legal advice in any context. Plaza does not guarantee or ensure any promise that information is provided is accurate. Terms and conditions of programs and guidelines are subject to change at any time without notice. This is not a commitment to lend, and Plaza Home Mortgage is an equal housing lender. Thank you. Okay, so I pulled up the agenda. Just want to quickly go over the things I'm going to be discussing. The member responsibility. So I'm going to go over the daily transactions and the reconciliations. You want to monitor your daily reports, reconcile them against your internal reporting. I'm also going to go over the monthly review reconciliation. This includes both the data reconciliation of the MERS system and also a document review. And last but not least, documentation. Your policies and procedures, the QA plan getting submitted, and documenting all your reconciliations and audits that you perform. All these activities are preparing you for your annual report review. So I'm going to start with the daily transactions and reconciliations. This is basically a MERS system transaction review against your daily activities. You want to monitor the daily MERS transactions in order to confirm that your transaction expectations were properly recorded in the MERS system. MERS has several daily reports. I've listed a few examples here to go over that are important to monitor and reconcile on a daily basis. You have your registration reports. You have your verification and your rejects and warnings report. You want to make sure that what you expected to register got registered in the MERS system. For example, Plaza, we have an automated interface with MERS, so our loans get automatically registered on a daily basis. Now, it's very important for us to go in there, pull our funding reports, we were funded, verify what got registered in the MERS system to make sure all our loans that we expected to get registered got registered. And also, you want to look at your rejects and warnings report because something may have been rejected or missing data or whatever it may be. You want to make sure you get those corrected. We also have our transfer reports. You have your rejects, pending, and overdue reports. You have several different transactions going on here, and all have to be confirmed or rejected. For example, correspondent. For us, we purchase correspondent loans, so it's very important for us to go in and check these daily transfer reports, making sure first our clients are properly transferring and timely to us, and we have to go in and make sure that we confirm those transactions or reject it if something's not correct. Plaza, we also transfer, the investor rights when we sell to aggregators. So, we need to check these reports to ensure that the aggregators are confirming them to complete the transfer, or if for some reason they're rejecting them, then, you have to reach out to see why and get that corrected. So it's very important to look at these daily reports. There's a lot of daily transactions going on. There's a lot of hands in there, so you really got to pay attention and keep an eye on those reports. Also, for us, we have 3 sub-servicers, and they perform transactions on our behalf as well in the MERS system. they'll transfer the servicing rights. And we have to go in and confirm their transfers as well to make sure that everything goes through. And we're also have to monitor them to make sure that they are properly transferring to any aggregators or wherever that needs to be transferred to. Yeah, like I said earlier, these are just a few examples of the daily reports that you should be monitoring and reconciling against your daily activities. Now we can move on to the monthly reconciliations. First, I want to talk about the monthly data reconciliations. What this is basically taking MERS versus the servicing system data. MERS will deliver the MRE reports, the member reconciliation extract reports on a scheduled day each month. And this is something that you set up with MERS. It's on a scheduled day, and they post to MERS online on that day. These reports have all the MERS data on all loans that show you as a servicer. If you service your own loans, you take this data and you compare it to your own servicing system and resolve any data discrepancies. Like I mentioned, for us, we have 3 sub-servicers, so there's a lot of reconciliation that needs to happen. So we need to work closely with them to do that data comparison as well. We've actually set up, which is a good idea, is we set up monthly reports with each one. So they're bumping up MERS MRE reports up against their system as well. And we actually have a scheduled report with them that they send us monthly of any discrepancies that they show in their system. So, we look at our system, we look at the docs, look at their system, figure out what's correct, and get those discrepancies taken care of. And of course, as always, you want to document and save your monthly results. All right, go to the next one. Okay, so this is going into the monthly review and reconciliation. This is document review. For the monthly doc review, you take a sample of loans, review the docs for accuracy. We do this to ensure our clients are properly drawing documents to adhere to MERS requirements, and our sub-servicers are correctly drawing and executing docs on our behalf according to MERS requirements. As a servicer of record on MERS, we are ultimately responsible for what they are doing, and so we need to audit accordingly. On the wholesale retail, we take a sample of non-mom loans and ensure that the proper assignment to MERS was done and saved into our doc imaging system. Example on something, we're a MERS member, so we would typically draw our docs all on mom docs. But the state of Maine, a while back, they decided that they will not allow mom security instruments. But there is an approved assignment to MERS that can be used. So in a case like this, each month we actually pull up every main property we did for that month and check for this assignment. It's pretty important that the verbiage is correct and the right assignment was used and recorded. Luckily, there's not a lot in Maine, but we have to check all of them. We also take a sample of the mom loans and ensure that they are drawing in the proper mom docs. Another example would be Washington, Oregon, and Montana. They require a special MERS writer to be attached to the security instrument. So, of course, when we're doing our sampling, we're sure to take samplings from these states to make sure everything's good with the documents. With the correspondence, we're doing the same review as above. We're taking a sampling of our non-mom clients to ensure the proper assignments are being executed. Take a sampling of the mom loans to ensure the docs are properly being drawn to MERS requirements. And as I keep mentioning, we have 3 sub-servicers, and because they execute docs on our behalf, we include them in our monthly audit as well. They perform deactivations for default, paid in full. They're drawing up and executing MERS assignments to Plaza or lien releases. So we have to take a sample of those transactions to ensure assignments that are MERS and the lien releases are done in accordance with MERS requirements. And of course, this is all documented and saved, which brings us to the next slide. Documentation, and the importance of having everything documented. So So you need to make sure all company MERS policy and procedures are documented and up to date and adhere to rules and procedures of MERS. You want to monitor any MERS changes, updates to ensure your applicable documentation is up to date. I mean, MERS will periodically update their rules and procedures. This is typically due to legal events or industry changes. And you want to make sure that this is communicated out to the affected business channels, you know, clients, vendors, subservicers, and internal departments. I used the example earlier of Washington, Montana, and Oregon. In the MERS rider, when events like this happen in the industry, it's imperative that everyone affected by this change is notified. And again, as a servicer of record, it's your responsibility for your subservices activity. So it's important that you confirm that your subservicer's policies and procedures are up to date and they are complying with MERS requirements as well. And on top of having all your internal documents and processes, you really have to make sure that it's important for you to file your QA plan timely with MERS and retain that as well. Your historical audits to help dictate your future audits. Examples, you want to take your last few audits and look at your findings. Now you should already have addressed these findings and they should be resolved, but you have them documented, have all your past reconciliations and audits documented. What you should always do is make sure for your new monthly selections you are taking samples of those type of transactions that happened in the past to ensure that those past findings actually have been resolved and are not reoccurring. You know, like I said, we have correspondent channels, so you know, it's imperative that they're following these purchasing loans. So it's imperative for us that they're following those MERS requirements too. So it's very important that you have all this historical data documented so you can perform these audits going forward to ensure everything is correct. That about wraps it up for me. Again, thank you for everyone for joining. Really appreciate your time. It's a pleasure being here, and I will pass this over to Janet now.
Thank you, Greg. I hope everybody can hear me okay. I really appreciate your insight for the member responsibilities. That's very important when a reviewer comes in to perform the annual report review. So in addition to the member responsibilities that Greg discussed, a member is subject to certain conditions, must file an annual report with MERS Corp Holdings every year. I'll be speaking on this annual report review process and what members should expect during the review. First of all, sorry, I went too fast here. I need to read the following disclaimer. The compliance group is not a law firm and thus cannot provide legal advice. The information provided in this presentation is obtained through various compliance sources used by the compliance group. The compliance group is not associated with any state or federal regulatory agency and therefore cannot guarantee how agency may interpret regulations or guidelines pertaining to this subject matter. Please contact your legal counsel if you require specific legal advice surrounding the information provided herein. So thank you for listening to that. The topics that, sorry, my mouth is very sensitive. The topics I'll be covering today will include the annual report review. This is the MERS requirements for filing the annual report. I'll talk about internal versus external reviews. In this area, I'll cover requirements for when a member must use an external reviewer. This includes thresholds and reviewer qualifications. Timing requirements. I'll be discussing when the annual reports must be filed, coverage periods for the reviews, and provide tips for review preparation. The annual report conditions. I'll cover the 6 annual report conditions all reviewers must include in the annual review process. For documentation, I'll be discussing the documentation typically needed during the course of the annual report review, and Greg did an excellent job identifying, you know, that you've got to document, because that is something that the reviewer will need. Lastly, I'll review the annual report filing requirements. Okay. So some key elements of the requirements to file the annual report. The members named as a servicer on one or more active MERS records as of March 31st of the current calendar year are required to file an annual report to MERS Corp Holdings. This includes all loans where the member is identified as a servicer, including loans that are interim serviced, in addition to loans subserviced by a subservicer. The annual report covers activity for each member's org ID in addition to any affiliate org ID a member may have. Members may have an affiliate org ID, but may not have active MERS for those org IDs, and as such may not be required to file an annual report. As an external reviewer, TCGs complete reviews for members who have multiple org IDs with active MERS that are managed by the same group of employees. We found that policies, procedures, and practices are typically consolidated for all org IDs, and in these instances, we filed the annual report for each org ID. But the conclusions are the same due to the consolidation of the MERS processes within the organization. Annual reports must be submitted on or before December 31st of each calendar year. I'll speak further on the timing later in the presentation. Annual reports must be signed by the member's executive sponsor, who is the liaison between the member and MERS entities and has full authority to act on behalf of the member. And members submitting the annual report acknowledge that they will comply with MERS rules and procedures topics not included in the annual report. So even though you've got 6 topics that you're going to be covering with the annual review, you are acknowledging that you're complying with all the MERS rules and procedures that may not be specifically identified in the annual report. Reviews may be internal or external on the number of active MERS as of March 31st of each calendar year. To determine whether the annual report must be completed by an internal versus an external reviewer, members must consider their active MERS count. Thresholds are identified in the MERS System Procedure Manual that indicate that servicers with less than 1,000 active MERS records as of March 31st of the current year may use an internal reviewer or an external entity if the member so chooses. Servicers with 1,000 or more active MERS records as of March 31st of the current calendar year must use an external reviewer. MERS Corp Holdings will notify each member if an internal or an external review is required, and MERS also identifies core qualifications for both internal and external reviewers. For internal reviewer qualifications, only the following MERS system contacts established by the member are allowed to act in the capacity of an internal reviewer, and that's a QA officer contact and the legal contact. And member employees are allowed to act in the capacity of an internal reviewer only if they're completely independent of the MERS system's operation. So like within an internal auditor, you want to make sure that they're not involved in the MERS processes and the operations. For external reviewer qualifications, third-party entities must be a review organization with demonstrable expertise and experience in quality assurance audits within the mortgage industry. And then for members wanting to utilize a CPA firm, MERS Corp may allow a letter of engagement as a proxy for a reviewer sign-off. Members must contact the MERS help desk for these types of engagement. Reviewers should follow the annual report reviewer recommendations as published by MERS, and they're required to report noncompliance. However, it's important to note that a reviewer provides feedback and recommendations during the review process that will assist the member in ensuring compliance with MERS requirements. It's a partnership. It's how we view it, and I know a lot of other organizations out there view it the same. You work very closely with the member to help them get those processes in place in order to be compliant. So members must provide remediation activities with target completion dates that are provided to MERS Corp Holdings in the annual report submission process when applicable. Uh-oh, my slide's not turning. I'm so sorry. Okay. Let's make sure. I think it went too far here. So sorry. Just a minute. Let me get back. Oh, no. Timing requirements. I apologize. Just a moment here. Okay. I'm looking at the slide number, and it's not matching up with mine. Some of the key elements of timing for the completion of the annual report include the coverage period. The annual report review coverage period should include the activity that has occurred since the last submission of the report. So a reviewer will come in, look at the last reconciliation, the last documentation the prior reviewer received, and that should pick up from that point forward. MERS provides an annual report initial notice. Once the member receives the notice that the current year's annual report is due, they may complete and submit the annual report. And these notices are generally provided after June 30th of each year. Members should be planning now for this year's annual report review. Some considerations in the planning include the determination and selection of an internal or external reviewer. For an external reviewer, you'll need time to receive proposals, complete the vendor management process if they're not already an existing vendor, and execution of the agreements, and this all can take up some valuable time. That's why early planning is good. Now is a good time to be doing this with your reviewers. The determination of an internal, of the key contacts who will need to participate in the review process. This would include a coordinator who can ensure the timely delivery of requested documentation, and there's a lot of documentation, in addition to assisting in the scheduling of interviews, on-site visit logistics, and they would act as a liaison between the member's staff and the reviewer. And then prepare the documentation that the reviewer is going to be requesting. Making arrangements to get some form of secure delivery methodology in place prior to. Other planning considerations, it would be to allow enough time to review preliminary results of the audit, agree or rebut any findings, and then review any revised results or reports, and then finalize the report and submit the e-annual report in the MERS system. And this all needs to be built in your timeline for the completion of your review. So, and the MERS System Procedures Manuals and the MERS Annual Report Reviewer Recommendations Guidance describe the following 6 conditions should be reviewed during the MERS Annual Report Review by either an internal or an external reviewer. There should be no difference in this process. And these 6 are exactly what you would certify to when you're submitting the e-annual report. So in an effort of time, I'm not going to read these 6 items. They're on the slide. I know it's going to be recorded, but I just do want to point out here that if the member is non-compliant for item number 2, which is the system-to-system reconciliation, it's quite common that item 3 is also non-compliant due to the fact that if not all fields are being reconciled, then a member cannot ensure the 2 systems are aligned and track discrepancies accordingly. So these are straight out of the procedure manual and the annual report reviewer recommendations. And this is what a reviewer has to certify to, basically. And so let me go to this next slide. These are the remaining 3. So the above, these 6 items are the annual report. So they're very important, and the recommendations by MERS on how to proceed. They give guidelines on what a reviewer should look for to ensure that the member is complying. Okay, so I'm going to move on to the next one. So members must provide supporting documentation for the MERS process, and part of the review includes a review of written policies and procedures pertaining to MERS processes in place by the member in accordance with MERS requirements. And so I put some in here that we always look for. registrations and data submissions. These should, beside your processes, we look to see that you identify data fields used in the data submission process. Again, that goes to your reconciliation of all the data points that have to be reconciled. Transfer of servicing or beneficial ownership. We're looking for processes, identified written procedures for that. Loan data reconciliation. Policies and procedures should include a reference or a list of the required and condition required data fields, in addition to identifying an acceptable reconciliation remediation period. So, for example, define the time frame that your company would like to have those resolved. Typically, you want to see them resolved if you're in the reconciliation by the next reconciliation. So just define that time frame that it should be resolved within 30 days, unless it's some systemic issue that's causing it, and it takes a while to get that systemic issue corrected. Sometimes there's an automated system that's uploading data, and it's discovered through the reconciliation process that it's putting data in the wrong data field, for example, in MERS system. So sometimes those take longer, and so you have those defined in your policies and procedures, that acceptable timelines to get those resolved. Reject warning reports, policies and procedures should include the list of required periodic reports to be reviewed, such as daily and weekly reports, requirements for the saving of reports. If your company wants to save those to show that you've resolved the issues, some do save those in shared folders that a reviewer can review. Any comparison reports that you have from your system that you utilize on your daily and compare to the reject and warning reports pulled from MERS. Identify those in your policies and procedures. Specific reject and warning resolution options, such as specifying the correct resolution based on the reject or warning circumstance. We usually recommend that your procedures do that for your staff. And then resolution timeframes, examples, just they are to be resolved typically within 90 days as an example. For the CRMS, this should include documenting processes in place and required periodic actions such as monthly corporate resolution reviews, quarterly attestations, signing officer qualifications, initial and annual signing officer certifications. Member profile, policies and procedures should include requirements for company changes, member contact information, periodic review of information, review of information, including user accesses. And then for the QA plan and QA performance, these should include the timing requirements for the periodic review of the effectiveness of the QA plan, such as a monthly, quarterly review, but not less than annually. We typically recommend that these take place more frequently than annually based on the servicer's number of active men. Let me just get through here really quickly. Required and conditionally required data fields for submission. Reviewers typically review the data submission information to determine compliance with data requirements. And then data reconciliation frequency is dependent upon the number of active men a member has as of March 31st of each year. So servicers that have 1,000 or more active men records are required to perform data reconciliation monthly. For those that have less than 1,000 active men, reconciliations are required to be completed quarterly. And when we're looking at reconciliations, as a reviewer, we're going to ask for all monthly or quarterly reconciliations, and we're going to look to make sure that all data elements are present, all of those. My next slide, I provide a list of those data conditionally and required and conditionally required data fields. So we're looking for all, if it's 12 months of reconciliations, we're going to look for all data points in all 12 months. Basically, MERS says if not all are included, that is an exception. So I do want to point out that some systems don't have all fields that MERS has, and so we highly recommend that you document when you don't have that data field, that MERS system has a blank value. In other words, the field is blank. and that there's no data going up into that data field. That's a reconciliation. So we look to that, and we recommend that you can use the MRE report to do that. I know some subservicers don't have a borrower or co-borrower corporate name. They just use the regular borrower name or co-borrower name, but you still have to ensure that those fields are blank in MERS systems. That is a part of the reconciliation. Ensure discrepancies or remediation activities are tracked and aged until cleared, and then must include all active MERS serviced internally or by a subservicer. And this may require separate reconciliation processes. Okay, and I did provide a copy. Here's a copy of the data field. The other thing that we do look for is member profile information. We look for making sure that you review monthly your profile information, so evidence of any member changes such as your legal name, corporate mailing address, website, and those changes, there's timing requirements on when those have to be provided to MERS. Your contact information, that information needs to be accurate and up to date. And so, and same with your global address list, your email address for service of process and other communications. Those all need to be kept up to date, and you need to show that you are reviewing that on a monthly basis. That's required. And we always recommend just putting an Excel spreadsheet together, have the month, have the item that you reviewed and that you signed it off, and then keep in a supporting documentation to reflect that you reviewed it. Maybe a screenshot or a current employee list showing that your contacts are still with the company. And then annual review should also be required for a MERS system security and user access. So make sure that you have a process in place to show that you're reviewing user accesses, all of them, at least annually. And again, you can use an Excel spreadsheet, an employee list to do that review to ensure that those that need to access have the access, and those that don't do not, or terminated employees are removed. Sorry, I'm flying through this real quick. I want to get through some of this, and we're getting very close here. CRMS is very important to make sure that you document your resolutions, your corporate resolutions, and your signing officers. So there are a lot of requirements there to make sure that signing officers are eligible and that they're performing their annual certification. And I'm just going to keep moving on here. So sorry. And then last but not least is your QA plan. Of course, you have to file that annually with MERS. And then I know very important is your random sample of loans that Greg mentioned, and how important that is to make sure that your documents, that needs to be a part of your QA review to make sure that you're in compliance. And that's a part of monitoring your performance against your plan. So the last section here, I don't need to really go through this, and that's the filing of the e-annual report. If you just go to the e-annual report guide, it walks you through that process. So most important from this is to very clearly identify, as a reviewer, we identify what the issue is if we found an exception and how the member is going to mitigate it. The member has the opportunity as well to enter their comments in there as well. Very important, MERS does look for those. They want to see what the issue is and what's driving the company not to have compliance in a certain area of those 6 area conditions. So with that, we did include some reference information here, and regarding the information that you found throughout the slides. And I want to thank you, Greg and I want to thank you for your time today and participation. And we've included our emails here. If you have any questions, please feel free to reach out to either of us.
Well, great. Thank you, Janet and Greg. Really appreciate that. A lot of great information on MERS compliance. I'll leave that slide up there for a moment. So if you want to get a shot of their email addresses, you have any questions for them, you can contact them directly. If you have a question now, you are invited to type that question into the questions dialog box. and we can take that and answer them for you on today's call. So while people may be posting some questions, I will continue to watch that box to see if anything gets posted. I just want to let people know that we will not be holding a webinar in August, but our next webinar will be on September 24th. We're talking about the new interpretation of UDAP by the CFPB, and our speaker will be attorney Sherry Safchuk from Buckley. So you'll be receiving information on how to register for that webinar probably at the beginning of September. I don't see any questions that have come in for Janet or Greg, so I think this concludes today's webinar. Again, thank you all for joining us. Hope you have a great rest of your day, and we'll see you in September.
Bye.